Welcome to our highly anticipated webinar titled Preservation of Your Inheritance, What You Need to Know. Together, we embark on an insightful exploration addressing vital considerations surrounding the safeguarding of our cherished legacies. Across Africa, many individuals delay drafting their wills until it is too late. Consequently, their bereaved families are often left mired in disputes over properties and legacies. Even when wills are present, some families face difficulties securing their rightful inheritance. Today's webinar is designed to cast a spotlight on these urgent concerns. We are privileged to host expert speakers specialized in probate matters and estate planning, ready to guide us forward. Their profound insight and actionable advice aim to empower us to protect not only our tangible assets, but the very essence of our legacies. My name is Frank Asa. I am honored to be your moderator today. Let us introduce our esteemed panel without further ado. We have our chief speaker, the Chief Magistrate Admin Ikeja Probate, with the Lagos State Judiciary, bringing a wealth of experience and expertise on family and probate matters. Additionally, we have joining us our in-house expert, Yewande Akomolede. You're welcome. And of course, next to her is Olapeju Olugbade. And of course, the last but not the least, Judith Musindi. All right, these expert speakers will navigate us through the intricate nuances of inheritance preservation. Let us also welcome the company secretaries of our most esteemed clients, and of course, all our attendees across the globe joining us from different platforms. Thank you all for embarking on this enlightening journey with us. Together, we will uncover the core principles of inheritance preservation, revealing what everyone truly needs to understand. As we transition to our first presentation, I want to invite our esteemed audience to type any questions or queries they might have during these respective talks. Of course, do well to kindly fill out the Google form filled in the chat box for feedback. We will address all your questions and queries at the conclusion of these sections. Please note that your active participation is greatly appreciated. Quickly, Your Honor, many have come across the term probate registry, yet its essence remains unclear. Could you please elucidate the primary functions of the probate registry?
Before I go to the functions of the probate registry, I first explain what probate registry is. By the rules of the State High Court, it describes registry or probate registry as the probate registry of the High Court. The probate registry is saddled with the responsibility of documentation in respect of the estate affairs of a deceased person. It stands at the core of probate business, whether contentious or non-contentious, because all requisite grants are issued by the registry. The chief registrar of the State High Court is the probate registrar of the probate registry. And most contentious applications for grant of probate, letters of administration, and other sundry applications are made to the office of the probate registrar. And this is enshrined in Order 61, Rule 1 of the High Court of Lagos State Civil Procedure Rules 2019. And some of the primary functions of the probate registry, I'll state them are stated below. And these functions are provided by the laws that guides the administration of estate law, and then the rules of the High Court of Lagos State 2019. One of the functions is that we issue and revoke grants of probate and letters of administration. And we also do other grants like amendment, additional assets. Grants are issued in respect of this. The probate registry also acts as a depository for such solemn documents as wills and codices. We also have the exclusive jurisdiction to the reading of wills. The wills that are lodged with the probate registry are read by us, and we can only read the ones that are read by us. So if you are able to identify one in your house that has not been lodged, you still have the opportunity to come and lodge as a detached will, and then we read it for you. Then we also collect and maintain an index of caveats entered in the registry. Caveats are like a warning that you give to the person that is applying for probate or for letters of administration that no, before you go ahead, please put us on notice, or we are against the people that are representing the estate. So until those issues are settled between them, then the file will be kept in limbo, and then we take it up from there if they are able to resolve it. If they are not able to resolve it, they go to court. So we keep a record of that. We also do enforcement of administrative bonds. Usually these are carried out where letters of administration are in question, that is, the deceased died intestate, and then letters of administration are issued. We have to find out whether the people that are, the persons that are coming up as personal representative are the proper people that are applying. So we have to put them through a lot of interviews and all that. So that's what we do. And recently we've made some improvements in the probate registry of Lagos State by introducing the e-probate system. That is, most of the things we do there now are electronically generated. We also have introduced cashless service, which involves the use of POS, online payments, and mobile transfer to the Lagos State Judiciary. We also have introduction of an electronic, automated, and fireproof archive storage system. And we also encourage our staff to go on continuous educational trainings and workshops. This has really helped in curbing some of the challenges that we have with the former way of doing things in the probate registry, because it has been able to address the issue of filtering of funds into wrong hands when we make payment by POS and all that means. Then it's also shortening the period of getting the LA and the grants ready. Thank you very much.
Thank you, Your Honor. Yewande, I put this to you, and I want you to respond to this. We often hear of instances where the deceased, didn't leave a will behind. In such situations, is it feasible for the relative to claim, the remaining assets? And what does the law, have in place for such a scenario?
Thank you, Frank. So yes, in the African society, really, you rarely see an individual, or in a room filled with 10 people, you'll hardly find one or two people that have written your will. Sometimes speaking about writing of a will is like a taboo, because there's that presumption that you're planning the person's death. So you'll find a whole lot of people that haven't written their will. And that is why the law has recognized this and made accommodation within the law for processing the letters of administration, which is for a person that dies intestate. So I'll just take us through the basic framework of what the probate means. So what's a grant of probate, right? This is a document issued by the Probate Registry of the High Court that gives a personal representative the legal authority to deal with the estate of a person who has died testate. When I say someone has died testate, that means the person died leaving a valid will. And if someone dies intestate, it means the person died without a will. So what's a will really? Because most people don't have that clear understanding of the definition. But I'll quickly take us through it by stating that a will is a testamentary document, which is also a revocable document. It's a document voluntarily made, executed, and witnessed by a minimum of 2 witnesses. And this has to be done in accordance with the law by an individual of sound mind, wherein he disposes his properties to his personal representatives, otherwise referred to as the executors to the will. This allows them to take charge of his assets upon his death. Now, an executor derives his power and authority from a will, while the probate validates that authority. You will understand that immediately the person dies, the will takes effect, and the executor has authority, but this authority has to be validated by the probate, which is what is referred to as the grant of probate. Now, the importance of a will cannot be overemphasized. It avoids your properties being taken over or transmitted to non-intended beneficiaries, and it also grants that financial security to the loved ones you've left behind. Now, note that it's not unusual, like I said, in Nigerian environment, that you hardly find people writing their will, because that's actually a very touchy topic to deal with in society. Now, this is why the law has made adequate provisions for the issuance of a letter of administration by the estate of a deceased person. Now, what is a letter of administration? This is a document that is issued by the Probate Registry of the High Court. This document gives authority to an administrator. It should also be noted that while it's possible to obtain letters of administration for a tested succession, what do I mean by a tested succession? It means the person died leaving a will. But if by virtue of a certain activity that will is invalidated, the person that can then come through a letter of administration to give validity to that will. Now, it should also be noted that while the probate confirms the authority of an executor, a letter of administration confers that authority on an administrator. Now, while it is also possible, it should also be noted that without the grant of an heirloom, the beneficiaries cannot legally access the monies or the properties a deceased person has left behind. Until that heirloom is granted, usually the property of such a deceased person is vested in the chief judge of the state where such a person lived before he died. Now, a letter of administration can be granted upon application to either a person in his capacity or through his legal practitioner. Now, generally, in the interest of security and transparency, the general provisions of the law does not usually allow for one person to seek or process a letter of administration. Now, the law requires a minimum of 2 people or a maximum of 4 people. However, in some jurisdictions, such as Kano, Benue, Jigawa, you will find that the law allows one person to be granted the letters of administration. Now, I'll quickly take us through an interesting part which most people usually wonder. Who are the persons entitled to the grant of the letters of administration? I'm sure most people don't even know there's an order of priority which the law recognizes. Now, the administration of estate laws of various jurisdictions provide direction on the order of priority of persons entitled to be granted the letters of administration. Now, Section 49(1) of the Administration of Estate Laws, Lagos, provides the order of priority of persons who could be granted a letter of administration. Now, these persons are first on the line is the husband or wife of a deceased person. Now, right after the husband or wife, we have the children of the deceased or the surviving issue of a child who died in the lifetime of the deceased. This ordinarily just means the children of the deceased or a grandchild of the deceased person. Now, right after them, we have the father or mother of the deceased person. Now, coming right after them, the law considers the brothers or sisters of the deceased person who have a full blood. Note, the law recognizes full blood and half blood. Now, the brothers and sisters of the deceased person who are of full blood, or the children of such brothers or sisters that are of full blood. Now, right after them comes the brothers or sisters who are of half blood, or the children of such brothers or sisters that are of half blood. Now, right after these people, the law then considers the grandfather or the grandmother. Yes, your grandfather or your grandmother could actually, if they're still alive, could actually process the letters of administration. Now, right after them comes the uncles or the aunties of full blood or their children. Now, it's also interesting to note, yes, that, and I'm sure a lot of people don't know this, your creditors actually, people you owe, maybe during your lifetime, could actually process a letters of administration if we are not able to meet all the other listed above on the order of priority. Yes, your creditors could actually seek for a grant of letters of administration. Now, last on the list is the Administrator General. If every other item or other person has failed, Now, the Administrator General of such states has the right to actually process a letters of administration. Thank you.
Thank you for that insightful piece of information. Peju, Yewande highlighted those eligible to apply for letters of administration. Could you provide insight into how asset transmission is conducted, particularly as concerns shares?
Okay, okay, yes, Frank, thank you very much. You know, a lot of people are bothered with the question, why is transmission important? And literally, we can define transmission as the sending or the passing of something. In other words, we can say the process or the action of transmitting something. So when we refer to transmission of shares, it is required where there is a deceased shareholder. It is a compulsory action taken in case of death, insolvency, or non-nasty of a member. The process is brought about by operations of law, which simply mean a devolution of title to shares, otherwise than by transfer by a competent court. While transfer of share relates to a voluntary act of the shareholder where the instrument of transfer is both signed by the transferor and its transferee or on their behalf. Who do I refer to as transferor? The transferor is the seller, that's the shareholder, while the transferee is the buyer. So the instrument of transfer must be delivered to the company, which is done via electronic means, and upon the application of the transferor, the name of the transferee will be written in the company register. So we can quite see that for transfer of share is a voluntary act of the shareholder. While the shareholder is alive, the shareholder can decide that, oh, I want to transfer part of my shares to my spouse or to my son or to my daughter. Even it can be for financial gain. That is your voluntary decision. On the other hand, if you are talking about transmission of shares, you know, this is a devolution of titles to shares. What do I mean by devolution? This is a delegation of power. This is brought about by operation of law. It is compulsory for the beneficiary to obtain this legal document from the probate registry. So, and the only person that is recognized to process this, to come over to the company to process this, it has to be the legal representative of the deceased, where he or she is a sole holder, or the surviving holder, where he or she is a joint account holder of shares. Actually, the deceased can be a joint holder. So the surviving holder has the right to come over to the company to process this. So the legal representative and the surviving shareholder will be required to produce evidence such as death certificate, you know, from the National Population Commission, the letter of administration, grants of probate, letter of introduction, the newspaper publication, legal notice gazetted from the courts, banker's confirmation, and copy of certificate and or dividend or CSS statement. So the procurement of the documents is very important, of which our experience and versatile probate team will help with the process of getting this legal document for the beneficiaries. And also our what's it called, our also experienced probate team also help with the confirmation of this from the issuing authority. So we can now say that it is after when these have been confirmed, thereafter we process the deceased account to be transmitted to an estate account for the accessibility of the administrator to claim the outstanding dividend and unit certificate. We also send us chat invite. You know, this is done via online, although it is peculiar to share account that runs into several millions of naira. The chat provides an important insight and also about the disease. It's also a way of having a deep understanding and accurate information about the beneficiary. You might be wondering, why are we having chat again? You know, I'll give you a scenario. You know, we actually received a letter of administration from a particular estate account from two different high courts. So the truth of the matter is that it might be that one of the party is fraudulent, and there might be faction in the family. So this exercise we carry it out on a large volume of estates. So this is part of our process and the requirement for transmission of accounts.
Thank you, Kweju, for that. That's good. Judith, coming to you now. Greenwich Research and Data Solutions is recognized for registrar business. How does it integrate into all of this scenario?
Okay, thank you very much, Frank, for that question. So it's no longer news that the beneficiaries of a deceased person's estate usually encounter a lot of delay before they can access the assets that may have been left behind by their deceased loved ones. It's for this very reason that we at GRDS, Greenwich Registrars and Data Solution Probate Services, have taken it upon ourselves to delve into this part to meet these challenging needs of our prospective clients and current clients as well. Now, our value proposition here at GRDS Probate Service is that we're a one-stop organization that offers probate service across the country using our wide branch coverage. Now, I will be listing a few of the services that we have put together to meet the needs of our prospective clients. So, number one on the list, a service that we render here at GRDS Probate Service is the procurement of letters of administration. We also procure the grants of probates for instances where wills have been left behind. Next on the list is the procurement of certificates of additional assets. After that, we also have in the past procured amendments to these letters of administration, grants of probate, or even certificates of additional assets. Another service we render here at GRDS Probate is the confirmation of letters of administration, grants of probate, certificates of additional assets, as well as other court orders, which have been gotten from different institutions, high courts in the country. Now, another service we render here are asset investigation as well as asset gathering, which we have done both for our individual clients as well as firms who do not have the time to do the legwork for this. So we have assisted in this asset investigation as well as gathering of these assets. Another service we render here at GRDS Probate is the transmission of shares, which my colleague Pedro just mentioned, which is actually the process of the clients gaining access to these assets themselves. Now, another service we render here is the drafting and oathing of power of attorney. Another service is we have also assisted most of our clients with the drafting and lodging of their wills at the probate high courts. Another service we also render here is the investigation, disposal, and apportioning of these assets. And last but not the least service we have been able to put together is the resealing of grants of probate or letters of administration, which we have done successfully. Now, why should you think GRDS for your probate needs? Why should GRDS be your top of mind for your probate needs? Number one reason we should come to mind is our knowledge of the industry. Now, GRDS Probate Service is able to guarantee a seamless execution of transactions due to the knowledge we have gained over the years in and out of the industry, as well as the business ability to work in tandem to achieve successful transactions. Now, another reason why you should think GRDS is our incomparable client relationship management. We have resourceful, knowledgeable, and in-depth staff who effectively and efficiently execute clients' mandates with timely reports of the strides. Now, another reason why you should think GRDS Probate Service is the good working relationship that we have built over the years with registrars and other financial institutions. That's one reason you should think us. Now, we also have a good working relationship with the probate registry, which we have built over the years of doing this business. As you can see in our midst, we have the Chief Magistrate, Johanna, here in our midst, lending her wealth of knowledge of probate service. This goes to tell you the relationship we have been able to build at these probate registries. Now, another reason why you should consider us for your probate needs is that we have a competitive and flexible payment plan, which helps to transform and maintain healthy customer relationship. And last but not the least is our excellent branch network. In the 6 geopolitical zones of the country, we are running a real-time basis, and these offices are manned by seasoned staff who are providing excellent customer service to all our clients. So thank you.
All right, thank you, Judy. Once again, I would like to invite our attendees and audience out there to please kindly type in your queries and questions into the chat box, as we'll address them after the presentation. Of course, also remember to fill out the Google form in the chat for necessary feedback. Yewande, coming to you again, can you tell us exactly what class of assets can be included in letters of administration or grants of probate?
Okay, so yes, in processing your letters of administration, all forms of assets can be considered, such as monies in bank, your securities, stocks, landed property, pension, everything that falls within a valid asset, yes, could be included while processing your letters of administration.
All right, thank you. Let me come to you, Judith. We've talked much about probate and probate services. Can you tell us exactly the different probate services that are offered by Grds?
All right. Thank you very much, Frank, again for that question. So number one on the list, we have assisted our clients with the procurement of letters of administration, grants of probate. So like we have all been saying, we know when letters of administrations are required, and we also know when grants of probate are required. Now, another service we render to our clients here at Grds Probate is the procurement of certificates of additional assets. Let's, for whatever reasons, maybe the initial letters of administration or grant of probate did not cover all the assets that belonged to the deceased. There will be need for a procurement of certificate of additional assets or further securities to be granted by the loved ones for them to be able to access those particular assets. So in the past also we have assisted a lot of our clients with the writing of their wills and preparation of powers of attorney. There are situations, for whatever reasons, maybe members of a particular or administrators to a particular estate, for whatever reasons, might not be around to go through the process of maybe transmission or even the procurement process at the courts. And there will be need for powers to be divulged to other administrators in that for that particular estate, to enable those present and available to be able to go through the process seamlessly. For that to happen, there might be need for powers of attorneys to be prepared. Another service we render here at Grds Probate are the confirmations of letters of administration and grant of probate. Over the course of doing business, we have received requests both internally and externally, and even from banks who have needed to confirm the authenticity of these legal documents that were gotten from the banks, from the courts. So for clients that might be needing that particular service to confirm the genuineness of maybe letters of administration or grants of probate, we should be considered, as we can assist them in this regard. Now, another service we render here at Grds is probate service is the amendment of letters of administration. So there might be need for these letters of administrations to be amended for several reasons. It could be as a result of maybe part of the administrators dying, or a name was not mentioned in the initial letters of administration, and in the process of us doing the asset gathering, we find out that such a client had that stock, and we need to cover that name. For this very reason, there will be need to go to the courts who initially granted this document to have that document amended. And this service is usually done at the High Court in the presence of a judge. Now, another service we render here at Grds Probate is the transmission of shares. Like my colleague earlier mentioned, it's the process where the deceased name in our records is now changed to read estates of, and whatever assets or dividends that have accrued in his names are finally paid into the estate account, and these loved ones can now have direct access to it. Now, another service we render is the investigation, disposal, and apportioning of these assets. We usually run this particular service in collaborations with our sister company, which is the Greenwich Securities Limited, who are a stockbroking firm. So we have met a lot of our clients in the process of, or after we must have procured all these documents for them, and they have even collected the benefits due to them in the transmission process, decide for whatever reasons to either keep the estate together or dissolve the estate. And for this to be done, they might need the services of a stockbroker. So all the shares will now be collated into an estate account with the CSCS, and depending on the instruction from the family, will now be disposed and apportioned among the administrators. Now, last but not the least service we render here at GRDS, a probate service, is the resealing of probates or letters of administration. This is usually done when properties, especially real estate properties, are found in other jurisdictions, and there will be need for the families to be able to gain access to those assets. So we will go to such states and ask the High Court of that state to include that properties in the letters of administration. So these are all the services we render here at GRDS Probate.
All right, thanks, Judith. Your Honor, let me come to you for the benefit of our attendees and others out there who will need to know, what is a bank certificate?
Thank you. A bank certificate is first part of the forms that are used to process letters of administration, the sealing, and additional assets and probate grants. Because it's not only in letters of administration alone that you use bank certificates. It's possible that the deceased has money in the bank. And if the deceased has money in the bank, there is no way any financial institution will release that money without you going through the probate grant. And when you are going through the application of a probate grant, that form is first part of the forms that we use in processing it. So it's a form that needs to be taken to the financial institutions where the deceased had assets in their custody. It could be a bank, it could be registrars where there are shares, it could be pension managers where the deceased has pension, it could be insurance companies. So all these institutions, if these bank certificates are taken there, they will endorse it and then put the balance of what is accruing to the interest of the deceased before he dies. So they bring back the bank certificates and then we collect all the assets so that we can work out our the estate fees.
All right.
So it states the personal charters, not real properties, because there's a different form for the real properties.
Okay.
Yes.
Thanks very much, Your Honor.
Yeah.
That's good. Peju, you spoke more on transmission earlier on. For those who may have bereaved ones who have left shares behind, what are the requirements, for transmission?
Okay, Frank. Like I said earlier on, the legal representative or the surviving holder will be required to provide evidence such as letter of administrator or grants of probate, letter of introduction from the executors as well, then the death certificate, newspaper publication or legal notice gazette, then banker's confirmation of signature. Actually, they will have opened an estate account in that regard. So we require the banker's confirmation of the administrators. Then we require the identification card as well. Then a copies of share certificates or CSS statement or copies of dividend warrants as well.
Thanks very much. Yewande, for those who may be interested in the services, probate services of GRDS, what is the cost of your service?
Okay, like my colleague Judith had mentioned earlier, GRDS offers a wide range of probate services. It's dependent on what aspect of that service. Is it procurement of letters of administration, amendment of letters of administration, will writing, lodgement of wills, certificate of additional assets? We are your one-stop shop for all your probate needs. So it's dependent. We have very flexible charges. So it's dependent on what aspect of that service will render to you. We're ready and available to meet your needs. Thank you.
All right, thanks very much. Your Honor, let me come to you again. During the course of this conversation, we're made to understand that there are fees payable to the government on assets declared. Yes. How can the settlement of these fees to the government be done when the deceased left monies in the bank?
Yes, we do have challenges with some applicants where they cannot make payment. Maybe they don't have the money to be able to pay the estate fees, especially where the estate is large. In that instance, because by the time they bring back the bank certificate, like I said earlier on, it is collated and then the value is worked out and then 10% is made payable to the government. So if an estate is a big one and they can't make the payment, they can't write us. They can write to the probate registrar by virtue of Section 7 of the Administration of Estate Law that gives the chief judge the vetted powers on the chief judge to administer the estate of a deceased person between the time the application is being processed until the LA is ready. The administration is vested in the CJ. So in regard with that section, they can write us and then we can write on their behalf to the bank that they make available the 10% that is accruing to the government. So we can do that.
Okay.
Yes.
So is that easy? I'm saying.
Yes, it's very easy.
Thank you very much.
And where it is property that is involved and they can't pay,
okay,
they can always apply, they can always make payments by installments.
Okay.
Until the
so GRS can help them to at least.
Yes, they can be paying by installment. But the only snag is that they can't have the early until they finish paying the estate fees.
Okay.
Yes.
All right. Thank you for that. Peju, a quick one, from you. How do we sell the shares and properties of the deceased when we have the letters of administration?
All right, Frank. Like my colleague have said, Judith, we leverage on the existing competence of our sister company, as GT Security and Property. The administrators can actually open accounts with our sister company, which is GT Security, that's GCL Security Limited. And our assets management arm of the group also help to optimize the assets to use maximum returns. So the administrator is rest assured that it is a one-stop shop. So all their fears is taken out.
Okay. All right, thank you very much for that. Judy, let me come to you again. Sorry. What if the administrators cannot afford the professional fees to Greenwich Raters and Data Solutions? What comes to play?
All right. In such scenarios, over the years, we have devised a means of ensuring that the reasons why these letters of administrations are not done, it's not because the family is not able to raise the funds to take care of the professional fees. So what can be done in this instance is that such administrators, especially for those of them that their deceased loved ones had equities domiciled with us, can give us an instruction here at JRDS, and with that instructions we can debit whatever our professional fees are from source here. So that can be handled here at JRDS.
All right, thank you very much. I'm still staying with you. Okay. Could you tell us how long it takes to procure letters of administration, grant of probate, and all of those?
All right. For each of these legal documents, for us to be able to procure them, there is no one timeline for them. Depending on what exactly it is that you require of us will determine the time it will take. Now, so let's take, for instance, we want to procure letters of administration, and this particular deceased person had just monies domiciled in the bank. We have a record to have been able to complete that particular process within 2 to 3 months, because it's just monies in the bank. So what happens is we go to the bank, we list the bank lists out exactly what is due to the loved ones. The loved ones work to raise whatever is the estate dues to the government, make such payments, and with their collaborations, that can be done within 2 to 3 months. Now, for instances where there is need or a client had a combination of assets, that means he had monies in the bank, he had pension fund contribution, and still had real estates, that might take a little bit of time. Like Your Honor had earlier mentioned, for large estates, the family putting together the funds due to government might be a challenge. So that might make the time a lot longer. So we've had a record of completing such process with the collaborations of the administrators within 5 to 6 months. We have done that. And for services such as amendments to letters of administrations, that one takes longer time because that will involve sitting in front of a judge, and we really do not have power over that. But we also have in the past completed such a process within 9 to 12 months. So these different services, the time it will take to complete them surely differs.
All right, thank you, Judith. Quickly, because we are having lots and lots of questions, and queries coming from our attendees and audience, so we can attend to them. Let me take this last one from Yewande. For the benefit of those who may quickly want to engage Grds for their probate matters, and services, where is Grds located and how can Grds be reached?
Okay, so our head office is located at 274 Mutula Mohammed Way, Yaba, Lagos. You could also reach us via our email, which is grdsprobateservices@gtlregistrars.com. We're also available on our social media handles on LinkedIn, Instagram, and every other Twitter also. So you could reach us on any of these handles. We're available to attend to your request.
All right, thank you very much. We want to take questions from our attendees and viewers out there, basically, and I want to also implore you to keep sending those questions and queries. We will address all of your concerns within our time. The first question here, and I'll put it to you, Yewande. Henry Fakriye says, are wills written outside Nigeria legally acceptable in Nigeria?
That's an interesting question. So the most important thing to note about a will is actually, the major things are, first of all, I mentioned it's a document that is voluntarily made. It has to be made without duress. I also mentioned it has to be executed and witnessed, a minimum of 2 people. Now, the will, now it has to be witnessed by a minimum of 2 people, and it has to be done in accordance with the law. Now, I'd mentioned that a will written outside Nigeria. Now, the question is, was it lodged? Because I think that's an incomplete question. You could write a will as long as you met every requirement, but was it properly lodged? Because I could travel and then I start writing my will, but while writing it, have I met every requirement? So it must meet the legal requirements, and as long as you've done that, it's a valid will. But also, if that will, by virtue of the fact that you didn't meet the minimum requirements in accordance to the law, it's invalid, it doesn't totally discard the will. You can actually go by virtue of processing the letters of administration and attaching that will to give validity to the will. So that will can still take effect through the processing of the letters of administration attached to the will.
Fantastic. I think that is well said. Okay. Let me come to you, Your Honor. Here, Oluremi Ogunfowa says, where the disease has met with an organization for the will and stated the details of the will and shown the various assets to the staff of such organization and sent funds to the organization. The organization confirms that the disease has made its intention known, but yet to be fine-tuned before the death of the disease. How can the beneficiaries get the will to be executed? I don't even get the question.
Well, if it's a valid will, like I said earlier on, because it's possible that the deceased died and then they discovered the will and it was not lodged. They can still come and lodge it as a detached will.
Okay.
But it must be with the consent of the beneficiaries. They must want to an affidavit that this is likely to be the will of the deceased person.
Okay.
So we take it in as a detached will.
Okay.
And then it will be read. Yes.
Okay. Just on staying with you again, please, Your Honor. Abayomi Akrele says, Your Honor, and it's even directed to you. You know, he said, where an applicant, a surviving administrator, requires certified true copy of letters of administration, pari, to filing of appointment of an additional administrator, but the probate registry cannot locate the file of the letters of administration. What can such an applicant do in this circumstance?
Well, it all depends on the jurisdiction, but for our own jurisdiction, what we do is this: we need them to bring if they can produce the original copy of the earlier LA, they will now write to the probate registrar that we should open a temporary file. So when we open a temporary file, we do a certified true copy from the copy that we have given them to create a temporary file so that we can work on the application. Because we have quite a lot of complaints like that.
Yeah.
But that's the way we have been sorting it out. If they can produce the original that we gave them, we use that original to create a temporary file so that we can work on the application.
Thank you. I'll also ask Abayomi to get in touch with GRDS and they can help you to get this done as quickly as possible. Let me come to you, Peju. Olayinka Obembe says, how can Nigeria-based stockbrokers be monitored or checked when they fail to produce full detailed CSCS statement of account for an individual's stock holdings?
I don't really get that.
Okay,
so he wants to know how to monitor.
How can they be monitored? Maybe there are some Nigerian stockbrokers who don't disclose full details of CSS statement of account of maybe beneficiaries or something.
No, like I said earlier on, apart from the copy of CSS statement, a copy of certificate can be submitted or dividend. It's not actually mean that it has to be CSS statements. So we can also make use of that to process the transmission.
And I think there are also regulatory bodies that do sanctions, the services of stockbrokers.
Yes, we have to.
Frame from his question, I think his question was, how do you monitor more like maybe as a beneficiary, you're not aware of the assets of the deceased person and how stockbrokers can be monitored.
Yeah.
That's where asset gathering comes in, because Judith had mentioned earlier as one of the services we render. By asset gathering, you go around, is it the registrars, is it the banks, you're able to gather adequate information, even those undisclosed to you by your stockbroker.
Yeah, that's another angle too.
When you're saying how can you monitor the stockbrokers? The truth is that if the deceased before in his lifetime had not gone to any broker to open a CSCS account and lodge his equities, his securities there, a stockbroker won't have that information. So you honestly can't hold the stockbroker in that regard. So it's based off of what the deceased had done in his lifetime that is the record the brokers will have. And for such scenarios, what we really do here at GRDS is we do not rely even on the CSCS statements that are provided to us. We have been able to identify 18 active registrar companies as far as Lagos is concerned. So whenever you come to us here at GRDS Probate, we make sure we go around these 18 registrars companies and collect whatever is in the deceased name. Whether there's a CSCS, it's a good thing you provide it to us. But in the event that you don't have it, we will not rely on that. We will still go around these 18 registrars and do the needful.
All right, thank you. As we proceed, I also want again to draw the attention of our audience and attendees out there. Please do well to drop your questions in the question and answer section so that we can be able to see them and, of course, address them accordingly. One more. I'll come to you, Yewande, again. Maurice Asokwo is asking, if the property is jointly owned, say husband and wife, can the husband still write a will on that property?
Yes, you can. But the joint ownership has to be recognized on that will. He can. You both own the property, so you can write it's your property. Only that it's jointly owned with another individual, maybe your wife or your sister or your sibling. Yes, you can actually still write it in your will, but you'd actually have to recognize the fact that it's jointly owned by you and the other individuals.
All right, thank you very much. Your Honor, let me bring Eunice's question. Eunice Mbojikwe says, how about issues of capital gain tax and inheritance tax?
Capital gain tax.
Yeah.
I don't understand that.
So, or maybe she's trying to know if capital gain tax or inheritance tax can also be included, as part of asset. I don't know. Though it's not very clear.
Well, that question is not clear.
Maybe, Eunice, you could throw more light as to what exactly you want to understand with regards to your capital gain tax and inheritance tax questions, right? Aneti Emmanuel, he says, do you independently confirm letter of admin from the registry? Judith, I'll produce to you.
Yes, we do. For every application that is submitted here at the registrars, and even a lot of financial institutions, those documents must be confirmed to be authentic before any dealings can be done on them.
Okay, thank you very much. Also, Judith, Taufik Babagbade wants to know, number one, who pays for probate validation? And then secondly, is there any profession or professionals that are qualified, acceptable to carry out, to conduct probate valuation or valuation for probate purposes?
Okay. So the first question is, who pays for the valuation? It will most definitely be the executors in the case of grants, or the administrators. They are the ones that will pay whatever is due to the government. Now, are they valid personnels that will be handling such? Yeah, he mentioned real properties. So for instances where a deceased had real properties, the Probate High Court has a unit, a division, that actually handles the valuation of these properties. So it's the Probate High Court that will determine. They will go visit the place, inspect the property itself, determine based on the market valuation, determine what is the cost of that property, and do their own valuation and do the necessary calculations. Lagos State, I'm aware, has a system where they have, in other states, it's usually 10% of whatever the worth of the property is. But Lagos State has done something. I'm very sure Your Honor can take a few minutes to enlighten what the Lagos State government has done. I know there's a 10% of what the property is, and a 35% of that 10% is now what the administrators or executors will now be paying to government in form of estate use. So, Your Honor, I don't know if you could take a few minutes.
I was wondering when you were saying who should pay for the valuation. It's the person that wants to take the interest of the estate that should pay for the valuation.
Yeah.
And we have trained estate surveyors that have been seconded from Alausa to be working in that unit. We have a valuation unit, so they are doing a professional job there. And the valuation is done in such a way, not at the market value. We don't use the market value. They first work out the fair market value. They use fair market value. So if you have a property that is worth, say, 50 million, the fair market value could be like 25 million. And then from the market value, they work out 35%, which is called the statutory fees.
Okay.
Whatever they get from the 35%, they now work out 10% from it. So at the end of the day, if you look at it, it's always a minimal amount of money that they pay. And the valuation units operate in such a way that it's not in every property that they go there on a physical visit. Some they use Google Map if it's not a developed property. Some, they are prototypes. So there is already fixed amount that those properties attract, so they don't need to visit. So it doesn't take time sometimes. But it's only where the properties are many and then it is developed that it may take time, because you have to provide the pictures of the development so that we know that what the staff are going to go and look at is what is on ground. Because of you know what I mean.
Exactly.
I won't say more than that.
Thank you very much. All right. Peju, an anonymous. This question is from an anonymous. We would like you to always put your name, but it's fine. We can take it. He says, please, what do you do in a situation where the executors or administrators cannot trace the evidence of purchase of shares here now, but they are aware that their late parents had shares?
Okay, that is good. You know, on our application, we have what we call global search. So we actually search for it. So if it is an account that is managed by GRDS, we take it up from there. So if it's not an account that is not managed by us, then the probate team will take it up from there. So it's not an issue at all. There's a solution for that.
Thank you very much. All right. Your Honor, let me come to you again. Eunice is trying to explain further, right? She's saying, is it true that the creation of a trust for your asset will help the inheritors bypass the difficulties of the probate process and infighting by family members?
For a disease, for a testator, you would have known the kind of family that is leaving behind, because there is no how. As human, when you are living with some people, there are bound to be some traces of some character that you will see that when you are gone, what you are leaving behind may turn out to be something else.
Yeah.
So in those instances, they go for trust. They go for trustees.
Okay.
I think something like that happened in. I don't let me know, because I'm in the here, and the person did it in such a way that no family member can sell the estate. So they gave it to private trustees to manage. So it remains in that trust fund. So it's not somebody. It's not that somebody will come and say it's my own and then we start fighting. In fact, there was one estate like that the man knew the kind of children he was leaving behind. So he gave it to private trustees to manage, and he did his will in such a way that they can't sell that property. They couldn't sell the property because he knew that those children would have sold those properties and then use it to take whatever they want to take. So the man did it in such a way that he protected that estate. So if you know and you have watched your family, you have seen maybe you have some castrant children and you know that you don't have problem when you go, you can use trust. But most of them always run away from it because of the cost. And then they said the cost is much.
Okay. All right. Thanks for addressing that question. An anonymous is asking, I think this question has been addressed during the presentation, is asking what is the time frame for getting a letter of administration, and can someone outside the country process it from Nigeria?
Yes, we have a lot of our current clients and even prospective clients whom we are in the process of procuring. We have procured a lot for most of our clients outside the country, and we're still doing it. So most of our clients are in the UK and the US, and everything we have done has been virtual. So, and based off of the relationship I have mentioned with the probate registry, we have even, for times where there is need for an interview, we have been able to collaborate with the Lagos State Probate Registry, and we have even had to do most of these interviews virtually. So there's a huge possibility for us to assist such prospective clients procure these documents.
All right, thank you.
The period,
okay.
I think the person also asked the period. I think
Yeah,
it's also dependent on the family's corporation, right?
Okay.
If they're able to provide all the documents, pay the fees, it's seamless. So it would take a period of between 4 to 6 months.
Thanks for that. JGD Wise is asking, maybe Your Honor, you could help us take this as well. The question is, if the deceased dies intestate and his spouse is joint signatory to all their accounts, do they need this account to be included in the letters of administration?
It all depends on the instruction that is left in the bank. If the signature if when you want to withdraw from the account, maybe it's one signatory that is needed. If it is the only signatory that is dead, then there is no way they will not add it to the early. They must apply for it because your own signature alone cannot take it out because it's the person that has been signing. If it's a company, it's a different thing. You know, if it's a company, it's just a change of director. Yeah. But in that instance, it can be difficult because there was an application like that. The guy, the man, and the woman, I don't know, maybe they are married, I don't know, maybe they are just boyfriend and girlfriend. So the money was kept in her account, in the lady's account. What that fund was, I don't know, because a lot of money. But I had this inkling that money is not a clean one. God have mercy upon me. So I did a lot of scrutiny before they could have it, before they could have access to it, because I said, if it's a company, then there is no need for you to come for an early. But unfortunately, it's a partnership. And it's not, a partnership is not like a company that is that predeceased the owner and all that. So I looked at that and then I said, go and look for a member of the family of the lady to be part of the early, because they should have interest in this money. You should not be the only one taking the money. So they were able to do that, and then we sorted that area out. So if a spouse has the other one as a signatory, but he has not been signing, no bank will want to do it now, because it could be a problem to the bank later. And the bank will want to protect themselves.
Yeah. Yes. All right, thank you. Yes. The same audience also asking, do you have a branch in Ibadan, and how would they access your service if you're not in Ibadan?
Okay, for our clients that are in the south west region, we actually handle it from here. Here from Lagos, because we have a lot of legal documents that we need reconfirmation, and so we are almost on a bi-weekly basis. We are at these states. So on a bi-weekly basis, we visit Ibadan, Ogun State, Ondo State, and so we can handle it from here. Yes.
All right, thank you very much. Peju, let me ask put this question to you. The Anonymous is asking, can beneficiaries with the letter of administration transfer the shares to themselves? I don't know if that question is clear enough.
The
beneficiaries,
that is, if their name is stated, it depends. If the name is stated on the LA, definitely you have been given right to process that. So if you are not available, or due to maybe ES or something, or indisposed to act on it, then you can actually give a power of attorney to somebody else to work on it, to transact that.
All right. Okay.
The beneficiary, that is the administrator.
Yeah.
So you have the right also to give a power of attorney to somebody else.
Okay.
To action that.
Okay. All right. Let me come to you, Your Honor, on this. It's an Anonymous is asking, what is your take on payable on debt forms? It says a lot of information has been circulated on social media saying this can be done at your bank. So funds in it can be transferred to your beneficiary stated on the,
The question is it backed by any law? Because for anything that you are doing, there must be a law that backs it up. I don't think it's a well-known practice in this part of the world. Because you don't just start a thing without a law backing it up. Because there are bound to be issues later. I know of a family that the father was using one of the child as a joint signatory to his account. When the father died, he wanted to take everything to the exclusion of the others. So this OPD they are shouting about, it will still have its own problem. I'm telling you. If you maybe you make one of your child as one of the OPD member. If it's a greedy type, you want to eliminate the others without having access to it. So there is and it's not OPD. It's not only money in the bank that the disease may leave behind. What of pension? If you leave pension, you still have to have early. You still have to apply for early, because if you don't have early, there's no way the pension officer will release the money to you. So if you're able to do that money in the bank alone with the OPD they are shouting about, what about pension? What about benefits in insurance companies and all that? And moreover, I'm saying it's not backed up by law. So they have to look at that first. Maybe they have to start from the House of Assembly or the National Assembly to ensure that there is a law that backs it up before they start.
Yeah, and if I can speak to that, I remember recently when WhatsApp broadcast messages were going on this. So I actually asked the banker, and he said, let him tell me the truth. He's been saying that message, that no bank, as far as this country is concerned, will attend to such. If you do not have a letters of administration or a grant of probate, then you're not going to have access to any money. What happens in a scenario where a man is lawfully married and at some point he decides to step out on the marriage and him and his girlfriend have enjoying that? What Nigerian constitution, who they understand are the rightful beneficiaries are his wife and his children. So because maybe at the time when the relationship was good, at the bank, this lady is a signatory, the bank will not listen to that lady. It is whoever can prove that she is the wife and the children of that marriage that will be the beneficiaries to that.
As stated earlier.
Yes. So letters of administration or grants of probate.
All right, because of our time, our producer telling us we are running out of time, but I want to take this one from Sylvester Oko, and he's directing his question to you, Judith, and Olakweju. It's quite a lengthy one, but I think he needs your attention. He says, we live in Calabar, Cross River State. Since May 2019, we completed all processes for e-dividend payment into the estate account of our late father. Is that up to now? Nothing has happened. The registrar is insisting that the High Court in Calabar must verify our early. I think I would advise Sylvester to get in touch with GRDS, through the phone numbers on the screen and also the email mentioned earlier by Yewande. I don't know if you can help them with the email address again so they can send their queries.
It's best because it's a personal issue. We can't take it online. We're live, right? So it's best to contact us through our email, which is grdsprobateservices@gtlregistrars.com. You could also reach us via our social media handles. It's currently flashing on the screen right now. Twitter, LinkedIn, Instagram. We would reach you. Just reach out to us and we'll help you sort it out.
Maybe one or two more questions. Yakub Omofeyiwa is asking, what happens?
There's also a Google form for people that have personal questions to ask. I would advise they also fill the Google form. It's been shared on the screen. There you can actually state all your personal requests, and then we could attend to you individually before data privacy issues.
Oh, definitely. You have certain specific, concerns or issues. Please fill the Google form, and you can be rest assured we'll get across to you. The question is this: what happens if a family member takes over the assets of a deceased without the consent of the family? A family member like the next of kin. What happens if a family member takes over the assets of a deceased without the consent of the family member like the next of kin?
Okay, in that regard now, we need to understand the question. How did he take over those properties? Did he do that legally? Does he have letters of administration that have granted him access? Now, there are scenarios where such a person, maybe out of greed, has taken over. Every other family member that is aggrieved can actually go to court, and the courts can place a caveat, as Your Honor earlier mentioned, and when the family tidies up their situation, then pending when that is done, then every other person can now take over. But we need to be sure what exactly is question.
The Sonto. Okay. And it should be taken to court. It's a trespasser.
Okay, maybe we'll just take this last one, and it's saying, for a property in a different state, can the administrator get a letter of administration from Lagos State?
No.
It has to be from the state.
It has to be from the state.
All right. All right. Thanks very much, my esteemed panels. We are grateful, for your insights, profound insights, and your advice. We also want to thank our distinguished attendees and respected speakers. Our deep appreciation goes out to you for your insightful contributions today. As we wrap up, I would like to remind you that Grds is ready and available to assist with any further services you might require. Please get across to us through the different platforms, and you will be reached accordingly. We look forward to future collaborations with everyone. Thank you for your dedication and, of course, your engagement. Thanks, and have a great day. Bye-bye for now.